on to their presentation.
Yeah,
So
they
it
don't
would
really
be-
have a presentation to make, they're here to basically respond.
So it's, yeah, much more beneficial if they respond after they hear the facts.
Yes.
So they would have to return as well.
I think the applicant has had more than sufficient time to respond to full comments on the letter of the
Frank,
officials.
we're-
I agree. I agree with Supervisor Fisher.
Elizabeth, you want to weigh in? You want to weigh in on it?
I think that they should have the opportunity to present whatever they would like to do. And then our residents should have the ability to respond.
Eric?
Yeah, same way.
I think
Unfortunately, they just have to be invited back to hear the whole.
well, I think the consensus is that we're not going to grant continuance.
Oh, continuous issue.
So I'm just saying, you want to present a case, if not, we're going to go into the,
I would just like to state for the record that the board's refusal to grant the extension is denying me the opportunity to put on a presentation, and denying me the opportunities under section 908 of the MPC. It's also a clear violation of your duty of good faith under the wrong decision in the highway materials case as well.
you understood.
Excuse me, I have a question for you.
Yes,
How
ma'am.
much time do you need?
I just wanted to continue this to next month.
Elizabeth, that decision was already made. They either can present their case or we're going to go on.
With all due respect, sir, I understand your position and I understand Mrs. Fisher's position. I heard two voices here that seemed willing to want to hear our presentation and then the residents' response to it. So I don't know if the board has made a decision at this point.
Yeah, but I got the intent of the board already. I got the decision already. No use looking at Frank, he already talked to us about it.
I don't have, because I mentioned that we didn't have, because of scheduling and an inability to put together materials, we are not able to put a presentation on here tonight. We're entitled to put our presentation in within the 100 days of the opening of the first hearing, and we ask for continuance.
Chairman Cecil, there's a resident that would like to.
Not yet. So if you're not going to put any testimony on, we're going to go. If anybody else wants to make any comments, you're still welcome to now.
I just have a procedural question. If they do file for another continuance, will they also be stopping moving the land around?
Well, nothing's going to happen with the land until we get resolved one way or the other. Whether there's an appeal, a decision in an appeal, or a decision in their favor, it'll all be after that.
Okay, because the land is moving in that area, so
Do they have a grading permit, Bruce?
I'm just out of curiosity. I was
No,
just
they do
curious.
not.
We're not moving land in anticipation of this application. There is work that's being done with regards to that hole that does not require any type of permits.
You're front regular.
But we're not moving anything in anticipation of the application. We wouldn't do that.
I know there's some people who had some information based on, they want to get in the record. Anybody want to at least put that on the record? Yes, sir.
You know,
Can you please come up to the microphone? And please hold the microphone so we can hear you better.
Hey, good evening. My name is Phil Donato.
Just pick it up.
I'm here as an attorney. I represent the three homeowners associations. And as I said before you, I'm also a resident. I live at 462 Ironwood Drive at Southpointe. I don't know what your decision is. I was a little confused. Have you decided to grant the continuance or have you denied? In any event, in the event there are further hearings, and for some reason I can't make it, I'd just like to put on the record from what I think a procedural standpoint, and I'd ask you to please consider it. I do not believe legally that conditional use is the proper procedure before you. As you stated correctly, what the applicant is really asking for here is a change of the use from residential or golf course to commercial. And I cite you section 913 of your ordinance, which deals with a special development district. And if you look at, if you look on page 181, It starts at the top in
But give us the section number, not pages, because sometimes, of course,
Yeah, 913 F2, deals with the situation where there's a proposed change in a land use category, which we have here. But if you go to 913G, that is the situation, once the land use categories have been approved, which we have here at Southpointe, they've been approved for years, that, in my opinion, is the section you must follow. And in 913G, the property in question, based on my review of your zoning map, is zone residential, developed as a golf course. And on 914G4, it has conditional use residential land use categories. And the only conditional uses listed in a residential land use category is traditional neighborhood design overlay district as provided for and subject to the standards and criteria as specified in Part 4, Section 403C, which is not what they're asking for, or additional criteria for a traditional neighborhood design, TND development in a special development district. I say to the board that once you've established these land use categories, the only way they can come before you as a conditional use is in accordance with the provisions of 913G, which lists the uses by right in residential land use categories, which this is a commercial use, it's not there, and the uses by conditional use. So I say to you, your own ordinance does not permit what they are trying to do here. What they're really trying to do here is to get a rezone, and they should be required to follow the rezoning procedures of your ordinance. This is, they are trying to attempt a rezone through a conditional use process because they know the standards are less. And I just point that out for you on behalf of the homeowners associations, all three of the homeowners associations who object to this development. They don't believe it's consistent with the plans of Southpointe, and I don't believe it's procedurally consistent.
Here, here.
Good evening. I'm Colin Fitch. I'm the solicitor for the Redevelopment Authority of the County of Washington. And I'm here just to put in the record a couple of documents and also let the board know what the Redevelopment Authority's position is. First off, I did on June 3 send a letter both to the supervisors and the Planning Commission explaining that the Redevelopment Authority intended to exercise its veto power, which is something that was provided at the inception of the Southpointe project in the Declaration of Protected Covenants. I lay out in that letter why the Redevelopment Authority retained the veto power with respect to any attempted re-subdivision of the golf course, and I wanted to make sure that that letter was in fact in the record here.
It isn't yet, but you can put it in now. At the time, it was premature when we got that because there was a hearing pending, and normally we don't take testimony or information like that prior to the hearing.
Well, that's fine, sir. I just wanted to make sure it's in there. And secondly, another document that I'd like to put in the record is it's a brochure which was prepared back in the day as part of the development of the whole Southpointe project. And I also, it's the original brochure which lays out why Southpointe was unique, live, work, and play. And it has a description of the golf course. It reflects the initial subdivision, the initial site plan anyway, of the entire Southpointe project, which laid out the fact that the golf course was the focal point of the entire project. And the residential, the commercial was all geared around that golf course. And that's the reason that the Redevelopment Authority feels strongly about not only the conditional use application, but also the subdivision application. That veto power is to is to maintain control over any re-subdivision of the golf course. And that's because it's important green space. All of the properties were conveyed with the understanding that that golf course would be there not only for 20 years, but for in excess of 20 years. You don't build an Arthur Hills Championship golf course and anticipate it's only going to last for 20 years. And after 20 years, it can be re-subdivided at whim. And that's why the redevelopment authority, because of the importance of that golf course to the entire project, and the fact that all of the parcels were sold with the understanding that this was going to be an ongoing project with green space, with a golf course. That's why it's important. And this document, I only have 2 copies, but I'll pass it around because I think it is very helpful in terms of understanding why the redevelopment authority continues to have an interest.
But not have to read mine.
It's pretty easy.
So you're offering that as to be put into evidence.
I am, yes. So just to reiterate and provide a little background with respect to the ordinance, I reviewed the standards for conditional use approval in a special development district today. And section 913C5 notes specifically, this is the Cecil Township ordinance, that conditional uses are subject to the redevelopment laws of the Commonwealth. And one of the reasons that this veto power was retained by the redevelopment authority was authorized by the redevelopment law. It's 35 PS section 1711(9). The redevelopment authority, when it exercises its discretion in terms of organizing projects and creating continuing covenants that run with the land, is allowed to insist on mechanisms which provide continuing controls as may be deemed necessary to effectuate the purposes of the Act. And that is the reason this veto power was retained in 2003 when all of the other controls and declaration rights were conveyed to SPOA, but it was retained with respect to the golf course. And that is because that golf course is important. It can't be re-subdivided without the redevelopment authority's consent. So I think to some extent, this application, this continuing use application is premature. There is a pending action. This was initiated by the golf course attorneys. There's a declaratory judgment action before the Washington County Environmental Police Court where this issue is right at issue, the veto power, whether it continues to be valid or not. And that has not yet been decided. It's still that litigation is still in preliminary phases. So I would suggest to the board that until such time as there is a resolution of that, by the Common Pleas Court, that action on this the use application or any subdivision application would be premature and subject to challenge. Not that that's what we want to do. My point tonight was to express where the redevelopment authority stands on this. So thank you for your attention. I'll try to answer any questions.
Would you agree that your veto powers, it's kind of separate, independent from the board's action?
You're the Cecil Township Supervisor Board?
Yes.
Yes, it is. Well, it is, but I think it's a matter of public record as well. I mean, I think it's integrally related because of the section of the code of your ordinance that I cited. I think it is interpreted, it could be part of what's before you with respect to at least a subdivision application. But yes, to some extent, we're talking about apples and oranges in terms of whether that veto power remains valid as a matter of law.
Well, will you be willing to put your information, I know you've cited some statutes under the laws of the redevelopment law. Would you submit that as part of a brief to the...
Sure. I can give it to your solicitor if you'd like. I can send him a
Or
letter.
if you agree, we'll hold the record open for that.
Okay. I'd be happy to do that.
Anything else?
Thank you.
Anybody else?